will gain an understanding. You will gain an understanding of how to protect your brand's identity, both legally and strategically. Also, you will have an understanding of of smart ways to align intellectual property with your marketing goals, and learn how to navigate trademark registration, enforcement, and the online risks associated with that. Also, you obtain real-world insights from experts in both branding, law, and business, with a range of years of expertise. Yeah, so it's gonna be an insightful session. Feel free to ask questions as we move through the presentation, or you could either raise your hand or type it on the chat box, and one of our co-hosts will be able to bring it forth to either the keynote speaker or the panelists. A brief introduction to who the organizations hosting this webinar are. So Panike is a boutique cross-border legal firm with 6 offices across Middle East, Africa, and Europe, including a flagship in Abu Dhabi and partner offices in Nairobi and Mombasa, through SMC Legal, offering multilingual practical expertise in corporate law, IP, M&A, real estate, and private wealth. Then Adi Marketing we are a boutique marketing agency based at the Sandbox in Nairobi. We were established in 2019, and we specialize in building top-of-mind brand awareness with one simple mission, which is to formulate unique marketing solutions for businesses to create meaningful and impactful results. And Sandbox is the first of its kind business growth accelerator that is modeled after an African village, where the principle of pooling resources, knowledge, and expertise for the holistic growth and empowerment and success of entrepreneurs who come to the Sandbox. The Sandbox brings together experts who work to ensure that entrepreneurs and their enterprises can sustainably flourish in the demanding environment of different crises and circumstances. So they offer different solutions that help you cultivate better business by building your knowledge and capacity, and ways to upscale your business. So through training, workshops, consulting, coaching, and networking. And that is it about the companies or hosting this lovely webinar today. Yes. Thank you guys for introducing yourselves. I will move on to the next session, which is breaking the ice. In this session, you'll be required to, I'll call out your name, and you'll be required to answer freely one or two of the questions on the screen. I hope we can all see the screen.
Yes, we can.
All right. So we'll start with the first question. I think we could do 5 for each, as we are 11 on the call. We could do 5 each on each of the questions. So the first question is, what's the best piece of advice you've ever been given? And we could start off with Becky. Becky, you could start us off.
Thank you, Njeri. My name is Becky Chair. The best piece of advice I've been given Okay, so this is in relation to my practice. I recently began my law firm. And one of the advices I've regarded so much is on consistency and ensuring that I do not take for granted any type of client, that be it that even if the income is not as much, if I would endeavor to garner a consistent type of clientele. So I think for me, this has been great, and it's a good advice for me because I thought I would begin, say with the big briefs or not, but knowing that I can begin somewhere and that any brief can work for me is something I regard. Thank you.
Thank you so much, Becky. Chabet, could you answer the same question for us?
Good morning, everyone. I hope you can hear me.
Yes.
Hello, can you hear me?
Yes, we can.
Okay, great. The best piece of advice I have been given, I don't know about best or ever, but I'll just say the most recent one that I had. So I'm an IP researcher, and there's a professor who told us that when you're researching, you need to think about what is a stone in your shoe when you're thinking about what research you're doing, so that you can have passion, be passionate in whatever you're researching, and you'll be able to figure out, okay, so this is bugging me a lot, and what can I do to either elevate, to remove it from it being an issue, and also how can I do it? So what is the stone in my shoe? That's the best piece of advice I've had. Thanks.
Thank you, Chabet. That's very lovely. We can have two more people. We can have Michelle. What is the best piece of advice you've ever been given? Michelle? All right. Emmanuel? Emmanuel? Rima?
All right, sure. Good morning, everybody.
Sorry?
And let me see. Best piece of advice given to me. I've recently heard breathe, so I'm doing quite a bit of that recently as well. It doesn't matter what situation it is. Just kind of just breathe and it'll help you to center yourself. So that always really helps in any situation. Yeah.
Yeah, that's good. Thank you for that. Next question is, if you could trademark anything about your business, what would it be? We could have Divina start us off with this, and then
Okay, trademark anything about my business. So I am in the legal profession. I don't know that this is trademarkable. I'm not trying to be funny, but I feel like the purpose of the business, the soul of the business, which is not really trademarkable, but our core sort of mission. I wish we could trademark that.
Yeah, that's very interesting. Elizabeth?
Hello, can you hear me?
Yes, yes.
Sorry, I'm on the move. I think I'd have to agree with Divine. I'm in the same field, the legal field, and I think especially for law firms, the purpose and what drives you when you're dealing with clients, I think, yeah, would definitely be the factor to trademark, although I don't think it's trademarkable, but definitely the purpose and the drive, the motivation.
That's good. We could have the last one go to Herom. I hope I'm pronouncing your name correctly. Herom.
You just got it right. For my business, I'll also agree with the two speakers who've gone. For me, the most important thing in my business is establishing the brand to be something that people can identify with, people can love, but most of all, giving that service to everyone. So my core values in running the business and the things is what I can trademark. So again, it's not a quantity, that's what the trademark, but it's very important to me in running the business, rather establishing the business.
Thank you for that. Thank you all who have participated. That was very insightful, and probably Divina could tell us more during her session why that is not worth of a trademark per se, and yeah, what actually about businesses we could trademark. So moving on to the next session, we have our first session with our keynote speaker, Divina, who is a managing partner at Sarangi Mwaniki and Company Advocates, which is SMC Legal, a full-service Kenyan law firm affiliated with Panike Partners. She advises local and international clients on corporate commercial law, IP, real estate, finance, regulatory, compliance, and more, with a strong focus on enabling sustainable business across East Africa. Divina is an advocate of the High Court of Kenya, a notary public, and a commissioner of oaths with legal training from the University of Nairobi, Kenya School of Law, and King's College, London. Welcome, Divina. We're looking forward to hearing more from your session.
All right, thank you. I don't know if you can see me.
Yes, we can.
All right, just to confirm, I'm not AI generated. So as you have heard, I'm an advocate. I've been practicing for over 9 years in Kenya. And intellectual property is one of our core practice areas. Now, we do partner with Panic and Partners. So we are their Kenya office, we serve as their office in Kenya, offering cross-border advice. Now, I will be generally introducing the topic, sort of to give you a taste of what the other speakers are going to be talking about. Now, I think, Jerry, if we could move to the first slide. So I think the first question I have, and maybe I would think you would have, is what is a brand and how does it relate to intellectual property? We hear the word brand a lot. Now, does it have sort of affiliations, or is it synonymous with intellectual property? Because in just normal speak, the two concepts are sort of used interchangeably. Now, I will begin with a definition of intellectual property, which essentially refers to creations of the mind, which are inventions or literary works or designs or symbols that are generally used by businesses in commerce to make them distinctive or stand out. Now, if you're thinking of intellectual property, you would be thinking of like the Nokia tune, which is copyrighted. Everywhere you hear that tone, it sort of brings to you in your mind Nokia, or the Mercedes three-pointed star. Wherever you see it, the word Mercedes doesn't have to be displayed, but in your mind, you know that that is Mercedes. Now, so that is intellectual property. A brand is not actually a legal term. It's not a legal definition. So if you go through our laws on intellectual property, which are the Trademark Act, the Copyright Act, and the Industrial Property Act, there's no actual definition of what a brand is. However, a brand is a bigger concept than, let's say, traditional trade names or trademarks, because it encompasses more. Now, the literature around branding is that it represents an emotional or even psychological component with respect to a product. So traditionally, you have a product, you have Colgate, you go register the trademark Colgate, and a trademark is just supposed to communicate the origin of the goods so that whoever is buying Colgate knows that the company Colgate made that product. It's also communicating a guarantee of quality. So there's an implied promise there about the quality of the goods or services under that brand. Now, so that is a traditional trademark, which is an element of intellectual property. But when we're speaking about a brand and the way brands are sort of growing, is that people are moving away from just communicate, or companies at least. When we're talking about corporate branding, companies are moving away from this, this idea that their brand is only supposed to communicate where the products are from. Because I think as we speak now, everyone knows the three-pointed star of Mercedes. It means the car was manufactured by Mercedes. But now there is this idea that there could be more communicated by a brand, such as what the values of the company are, or its purpose statement, or even the social issues it stands for. So of course, this is growing in line with consumer consciousness, because people are not just content to sort of buy products. Choices are being made for various reasons. So people are concerned about issues like climate change. They want to know, is this company I'm buying from, does it also stand for the same things I stand for? People are against animal cruelty. They want to see that maybe even if they are not vegetarians, they want to see that the animals that are being slaughtered, they're not being slaughtered in inhumane ways. They want to know about diversity and inclusion. So they want to know that the brands that they are giving their money to do not represent, companies that are not representative of races or the world as it looks now. So various races or ideas, just in terms of general inclusivity. So a brand in that context not only encompasses the trade name, it also encompasses the company's statement and purpose, a statement of purpose, and as well as the logo. So as you can see, it's a bit of a bigger concept than a trademark. And this is because people are associating names with visual identities, which then also generate or trigger emotional reactions. And these emotional reactions are based on the promise that a business is putting out there about its product. Now, there are legal thresholds. Sorry, Njeri, we can move on to the next slide. Now, there are legal thresholds for registering a brand or a trademark. In Kenya, this is under the Trademark Act. So in terms of the three main elements, a brand has to be graphically represented. And I think Njeri had sort of alluded to that I should explain why the soul or maybe the purpose of a business can't be trademarked. So this is one of the reasons. It's that a trademark or a brand has to be capable of graphical representation. So there has to be a word or a logo that can represent the brand. And then it can't be generic or descriptive. It can't be, you can't be starting a brand of sandwiches and say the sandwich shop. That is just descriptive of the product you are selling, or the tea shop, yeah? So there has to be something a bit unique and original about it. Maybe an example I could give is Kericho Gold, which is a tea brand. So they did take a geographical indication of Kericho to put in people's minds where they are sourcing this product, but then they put the word gold on it just to make it a bit distinctive. Because if they had said Kericho tea, you know, a lot of people source their tea from Kericho, so that doesn't make it distinctive. The other thing is that it shouldn't infringe on existing brands. So when a company is sitting down to decide its branding strategy, or at least at the conceptual stages, it should be looking at these three things. Have we actually graphically represented our brand, whether it is a word or a logo or a tagline, or even a tune that is associated with that company, which can be copyrighted. So, and then is it generic, or does it have at least some element of uniqueness? And then does it infringe on other people's brands, in the sense that it should not be deceptive? You should not be trying to take, you know, Safaricom green and using some iteration of the word Safaricom to establish your brand, because that is already an established brand. So intellectual property law is sort of the legal basis for protection of brands. And as I say, there is ongoing literature about that brands are now outpacing traditional trademark law and traditional trademark and copyright law, because corporate branding is now growing beyond just telling people that this is the origin of the product. So there is messaging, there are campaigns that are trying to tell people about the social issues that companies are involved in. And as we will see in the later part of the presentation, branding is growing to be more personalized and responding to consumer consciousness. Now, maybe the other thing we can talk about is, how does a business, so you already have a brand, how does a business then maintain and achieve, at least achieve or maintain brand integrity? So you already have your brand, you've set up your business, you've registered your trademarks maybe. How do you, over the course or the life of the business, maintain brand integrity? So I think the first step is that you should already have registered this trademark, because registering trademarks, which are territorial. So what that means is, when you register a trademark, it protects your trademark in Kenya. So it doesn't protect your trademark across the world. You have to go to these individual countries to register your trademark, depending on how sort of how your brand is growing. Now, there are, of course, international systems that make it a bit easier to register across the world, but trademark registration should be your first line of defense. So with registration comes certain rights, and most of intellectual property rights, the form of protection they give you is that you can prohibit others from using your brand. So if you see someone actually using the same brand as yours, you have the right to issue a cease and desist letter or take whatever legal action you want and claim damages. Now, the other thing is being vigilant in monitoring for counterfeit products. This might involve additional costs, for example, deploying people in supermarkets to try and see if someone is actually copying your brand or at least deceptively using your brand. And I think a good initiative has been started by the Anti-Counterfeit Authority, or at least it was in 2023, which was recordation of trademarks. So what that did is that everyone who has a brand that is registered in Kenya was supposed to register with the Anti-Counterfeit Authority, and the intention was to prevent importation of counterfeit goods, so that at the point of importation, they're checking who is actually bringing these goods into the country, and is it the person who registered the brand with us? So when it's not, then they can have questions and sort of try to find if these are actually counterfeit goods. Now, another thing is domain name registration. So a lot of these big companies have had problems with domain names because of something called cyber squatting, which is where maybe someone comes and registers some iteration of maybe Mercedes-Benz.co.ke. And then when Mercedes comes to Kenya and wants to register its digital assets, they're sort of prevented from doing it. So if you are a business that is starting and you think your business will have a lot of traction, it would be good to register domain names in different variations, .org, .net, .co, because now trademark spotters will use all those kinds of variations. And then when you want to use your domain name, you will have to pay them to actually access your domain names. Now, as I said, another element is legal enforcement. So, of course, this is where we as lawyers come in to send cease and desist letters and initiate litigation. But the only person who is properly entitled at law to institute legal action is then the person who has the trademark registered. Yeah? Another element would be consumer education and awareness campaigns. You've seen a lot of businesses these days sending alerts or messages to tell you maybe this person is not associated with our brand, or if you see this kind of message, this is not coming from us. So those are the kind of campaigns that a business can initiate with its customer base to sort of prevent watering down of the brand and to maintain brand integrity. And okay, the sad thing that I notice from practice is that when a lot of companies start up or are setting up, and of course, there's a realization that setting up a business is at least at the beginning, there's very high costs, a lot of decisions to be made. But what happens is branding becomes almost an afterthought. But if you look at brands like Nike or Mercedes, these brands right now, if you take the brand valuation alone, it might be even more than the valuation of the, or it might be at least more than 60% of the valuation of the company, just because of how much they have invested in protecting and maintaining their brand, so that, you know, in the most remote parts of the world, a certain brand is known and it communicates something to a customer. Now, I also maybe wanted to speak a bit about the emergent trends in branding, and I think maybe I've touched a bit on this as I've spoken, but there is this feeling that branding, corporate branding is growing. So people are trying, or companies, as they pursue corporate branding strategies, are trying to come up with ways to engage the consumer, which is becoming difficult because we are in this social media age. So getting people's attention is actually becoming harder and harder. So there is personalized consumer experiences where people are trying to appeal to a specific individual as opposed to, you know, faceless masses where you're saying, this is Colgate, you know Colgate, you know, buy Colgate because you've always known it. So people are now sort of investing in personalized experiences where they're asking customers to engage with them, to create even ads, to give a human touch. And I think maybe Rima will speak a bit more on this. There is also purpose-driven branding. So as I said, companies are willing to speak about the issues that they support. So you will see a lot of brands in their CSR or corporate social responsibility messaging, trying to be like, we support, you know, we support, we stand against racism, even though it has nothing to do with the actual product that they sell. But that is communicating to customers that by supporting us, you are also supporting some disadvantaged people, and that has a feel-good effect on customers. Now, there's also sensitivity to Indigenous people's intellectual property. Now, this is, although we have legislation protecting the intellectual property of Indigenous people in Kenya, this is very little known, or I think I haven't seen a lot of case law around this. So in 2016, the government enacted the Traditional Knowledge and Cultural Expression Act. And this act was supposed to prevent, let's say, people from taking the intellectual property or traditional knowledge of a community and commercializing it without ultimate benefit being flowing to the community. The examples of this I would give is, I think this was a while back, so I can't state the exact year, but I know an American flew in and was studying the Maasai people and took their biodata because Maasais have tolerance for dairy, a very high tolerance for dairy, and there's a lot of dairy intolerance going on in the world. So there was scientific research around that. So this scientist came in, took their genetic data, did not actually inform them or tell them that he was going to commercialize this. Yeah. Another maybe example I can give is there was an attempt to register the word Kikoi as a trademark. Now, when we think of Kikoi, we think of the garment, and we know that it really doesn't belong to anyone. It's almost a coastal garment. But the fact that someone wanted to register that and commercialize it would have stopped everyone else from being able to use that product, yeah? Or at least that word. So I think there was government intervention around that stopped it. So again, an element of branding is also being sensitive to such issues, because you also don't want your brand to be associated with negative connotations or taking advantage of people. So there's more of an awareness around that, and compliance as well. So there are a lot of laws, and maybe in the past people felt like they could flout laws, but we live in an age where, you know, everything can be recorded. News has sort of been decentralized, so reviews can be done in a second through someone's phone. So if a company is seen as not complying with something, maybe it is flouting the law in a certain specific way, a consumer can actually just give a review or an opinion, which can even sink, you know, a company. So these are issues we might not have seen maybe 10 or 20 years ago, but these are now issues that are becoming more prevalent and important to branding. So I don't know whether any of you has any question around this topic that maybe I can address.
Hi Divina, I have a question.
Yeah, sure.
So if someone has trademarked their say for example the visual identity, which is the logo of the brand, and obviously I'm going to speak around that a little bit later. Would they have to showcase the TM on the logo, or it
No,
doesn't?
no, that's not a requirement here. I see that in a lot of American brands where it is a requirement actually in America to show TM. But here, as long as the trademark certificate has been issued to you, you know, and it is registered, then that is enough. Although nothing stops you from, you know, sort of playing around with your logo.
Right. Okay. Yeah. And so like for example, if someone is trying to copy you with your logo and your brand and your name and things like those, then even if you don't have the TM written on your logo, and be able to like sue them, if you will.
Yeah. You see, when we are, especially when we're initiating cease and desist action, the first thing we're telling these people is we are the registered proprietors, and here is proof of our registration. And if you have proof of registration, show it to us. You know, so as long the person with the registration certificate is empowered under the law to prevent all other people from using that brand, unless now, you know, companies enter into assignment sort of arrangements. So unless you've actually assigned a right over your trademark to another party, then that party can use it. But barring that, you can initiate action. There's no requirement to actually show that TM sign on your logo.
Okay.
Yeah.
Would it sorry, just a final question on that. Would it actually stop somebody from trying to copy you if they see the TM? Is it something that would help with regards to, you know, kind of stopping them doing that?
Okay, from the instances that I have dealt with, honestly, no. You know, people who are counterfeiters are actually just riding on a brand. So as long as the brand is well known, they're trying to be deceptive about it because they're trying to ride on, you know, whatever investment you've made in the brand. So in my experience, at least the ones I have come across, because it's not very prevalent that people are using that TM. I know in other jurisdictions it's a requirement to have that, but here in Kenya it is not. So I don't see that it would stop someone who had made the intention to sort of go down the path of maybe counterfeiting or using your brand. As long as you have your certificate and you issue a cease and desist letter and also report such people to authorities like the anti-counterfeit authority, then those are the sort of protective steps you would take.
Got it. Thank you.
All right. Any other questions?
Yes. Hello?
Yes.
You can hear me, yeah?
Yes, I can, Emmanuel.
Yes. So my question is on, I think you have talked about the registration, but I know, I think there's a concept where there's long usage of a particular mark, then you can use that as a defense, even though, I mean, somebody new come and tries and register. I mean, you can argue that due to long usage, then I'm entitled to this protection. So I don't know whether you can touch on that concept. I see some people normally raise it as a defense.
Yes, there is that, but now, you know, when it comes to court has certain rules, and part of them is the evidentiary process. So sometimes proving, unless your brand is very prevalent, proving a long period of use might actually be a difficult evidentiary sort of mountain to climb or hurdle to get over. Yeah. So I do advise clients to register, even if you've been using it before. It is a good step to actually register it, because all things taken into account, registering a trademark is not as expensive as people think. The process does take 6 months, but at least once you have that trademark certificate, it does give you sort of an upper hand. So yeah, there are instances where long use can be can sort of help, but registration would be, I mean, for me, would be the best route.
Sorry, I have another one. In a different sort of scenario, if you have an already existing brand, maybe a few years in, but then say, for example, a new brand came and you didn't register it, and a new brand came along and registered theirs, which is similar to yours. You know, and they registered it. So then does the old brand have to like redo their branding, for example?
No, so that is tied to Emmanuel's question. Where you can prove long use, you can actually prevent a new party from using your trademark. But and there are exemptions given to these very well-known marks. For example, like Coca-Cola, or I know the Olympic game logo can't be used by anyone. So there are brands that are protected internationally just by virtue of how well known they are. Yeah. So right now, maybe someone trying to go register Mercedes would be a very long shot. Yeah. Or the three-pointed star of Mercedes. But as I say, registration should be the first port of call because legally it affords you a lot of protective rights for your brand. But long use can be used to establish that you have prior rights in the trademark.
I think I'm also coming from a perspective of small, medium enterprises or startups, for example. So a startup goes and like does like the first part of you know, running the business and growing it and so on, but they didn't actually trademark it, right? But say for example, they're 6 years old. And then a new player comes in, does about the same amount of stuff, and then just quickly goes and registers it as a trademark. Then now you see, I get, you know, you can't go an iPhone and Mercedes and things like those. Those are really high, far-fetched, and probably you know, like and still there's counterfeits around them as well. You know, you still Mikey instead of Nike in the market, you know, and people actually purchase Mikey, you know, sort of a thing.
Yeah.
But I'm even the reasons why I'm bringing this up is because a lot of startups and SMEs come to us around this conversation, and you know, from coming from that perspective, what would that look like if someone who's a new player comes and registers, and then the older one who's a startup 6 months old, 6 years old or 3 years old, is that situation?
So what that would entail for the unregistered initial user is you would have to mount litigation proceedings, yeah, to try and stop the other one, which then comes to this point that I'm saying of you have to prove this prior use in a substantial way, you know, and how prevalent your brand was that you've been using it for this time. So for me, you see, the whole point of you even having to go to court to protect a brand you've even been using, incurring these legal costs and maybe fighting battles over years, this all can be avoided by just registering your trademark at the beginning. So it's not that you don't have rights, Rima, as a person who's been using your brand. It's just when someone else then goes and registers it, that puts you on the back foot. And this can be avoided by just registering your brand on the outset. Maybe something I can add on this is the company's registry and the trademark registrar did notice that, you know, sometimes a company will be formed. Maybe it is Betika Limited, yeah? So they will go and register a company called Betika Limited, but someone else will go after and maybe the Betika Limited didn't go and register Betika as a brand, for example. then someone else will go and register Betika. So what the Companies Act has sort of come in place to try and protect is this issue of where a company is already registered and it is using its name as its brand, and then someone tries to go to the trademark registry to register that name. So right now, when you try to register a company, what happens is a search is done on the company's registry platform, and it's also done with the trademark registrar to try and stop those instances, yeah, where maybe I have always registered, or maybe I have an entity called Divina Limited. It's been operating for maybe 15 years, and Divina has now become a brand sort of on its own that is affiliated with my business. So that stops someone from going to the trademark registry to try and register Divina, yeah? But now when it comes to court litigation, as I say, court procedures are a bit different. There, what sort of wins the day is the evidence. And sometimes the person with the certificate does win, because sometimes proving long use, we go back to clients and we're like, okay, give us invoices you've issued in this name, or give us communication you've sent to your clients in this name. And sometimes they don't even have such records, but they're like, oh, this is our name, we've just been using it forever. So those are the kind of issues that can be sort of that don't have to come into play when you register a trademark. I don't know if I've answered your question.
Yeah, sure. Thanks.
Thank you. Thank you for the questions. Thank you, Divina, for the session. I think it was very insightful. If anyone in the call has any more questions regarding to Divina's session, feel free to drop it on the chat box. She will be able to answer it from the chat box, or being given a chance at the end of session 2, which is our panel discussion. So our panel discussion is being led by our marketing expert, who is Rima. Rima is the founder and CEO of Adi Marketing, and the marketing expert at Sandbox International. She holds a CIM professional diploma in marketing from London, with over 15 years of marketing experience in the corporate world. Her expertise is in marketing strategy, marketing training and coaching, and reputation marketing, with a keen focus on content marketing and customer experience. She is passionate about targeted marketing, loves supporting women in business, and has been a marketing trainer, mentor, and coach for startups and entrepreneurs with various ESO training programs. Joining us also on the panel is Chebet Koros, who leads research on intellectual property and innovation at the Center of Intellectual Property and Information Technology Law at Strathmore University, focusing on shaping IP policy in Kenya, supporting regional reform, and contributing to global discourse. Her work explores copyright law in the context of emerging technologies, ongoing reform across Africa, and negotiations at the WIPO SCCR, with a focus on public interest through limitations and exceptions. She also develops IP training and has co-authored a practical copyright handbook for Kenyan creatives and practitioners. Also leading this session is our panel facilitator, who is Loretta Nyanchoka, a legal advisor at Zarang, Moniki and Company Advocates, which is SMC Legal, where she advises on intellectual property, data protection, commercial law, and regulatory compliance. With over 6 years of post-admission experience, she supports clients in managing IP portfolios, navigating digital innovation, and mitigating contractual risks, while also contributing to litigation and policy analysis. She is an advocate of the High Court of Kenya, a notary public, and a commissioner of oaths, and holds an LLM in intellectual property from the University of Cape Town. Welcome to our moderator and facilitators. I will hand this session over to Loretta.
Good morning, everyone. Thank you so much for joining us for the webinar today. We are very glad to have you all here. So I will be facilitating this very interesting panel discussion where we'll be talking about the value of a name, the intersection between branding, IP, and the digital minefield. I think Divina has alluded a lot to the challenges that we're currently facing in her presentation. And we are all alive to the fact that we're living in a time where it's easier than ever to start a business. You only need a name, a logo, and probably an Instagram and TikTok page, and you're good to go, and a pay bill so that people can pay for your products. But then usually we encounter a lot of challenges when we talk about what happens when that name becomes valuable. I think we have also alluded to that in the keynote speech. And then what happens when somebody tries to use your trademark or your brand or your logo? And worse off, what if somebody registers it before you register it? So on your screens, you can see something that is placed there. I'd like to talk about two case studies of two businesses and how they handled products in two different ways, or their businesses in two different ways. The first one has been dubbed by the internet as the Battle of the Lip Glosses. For those who have seen this debate online, there's this business called Lip Essentials. They had been selling lip products, so lip care, lip balms, lip glosses, and all of that. They had been selling it for a while. And within their portfolio, they had co-opted an influencer to help them to kind of like push their product. So this influencer would take videos or create user-generated content using their products and telling people this is where I bought it, and basically promoting Lip Essential as a business. Over time, this influencer, who is equally passionate about lip products and all of those things, started her own business called Lip Tribe. And Lip Tribe is selling more or less the same products that Lip Essentials is selling. And the debate came up that this person is stealing this person's business, this person's idea, this person's brand, and they're co-opting it to be their own, given the relationship that they had initially had. And of course, this debate is, in as much as there's some weight to what they were saying, that this influencer, having the privilege of working with Lip Essentials, had an insight into the business and all of these things. And her starting her own business was a bit, underhanded. Can we say that Lip Essential actually had any legal legs to stand on, which is the debate that we are having right now? As Divina mentioned, a brand is more than just a name or a logo. It is a promise, it's an experience, and it's the reputation that a business carries. It's how businesses remember you, how they refer to you, and how they trust you, especially in today's noisy, digital, fast world. And how you protect your business. Intellectual property, something that we're going to be discussing, is not just, we're not just telling you to waste your money to get those registrations done, but basically it's just a way to protect your business, which is something that we're going to discuss. And in the next slide, I'd like to share with you a business which actually used intellectual property to secure its brand, and that brand is M-Kopa. So M-Copper, as we all know, it's a widely known fintech company that built its reputation on providing asset financing for smartphones and solar energy. So in 2023, one of its former employees by the name John Waweru, he left the business and then he opened another business of its own, and the business was called M-Copper Customer Care and Accessories. So he kind of used somewhat the same spelling. It's not the same spelling, but like if you are looking at it quickly, the M-Copper can look like M-Copper. Then they use the same colors, logo, so it closely resembled the M-Copper brand. So M-Copper, who have a trademark in the way they have a trademark in the name, the logos and the colors and all of that, they went to court. And as recently as 2025, this is a case law that we have in early 2025, the High Court actually ruled in favor of M-Copper, saying that M-Copper had come up with a product that is quite similar and could confuse customers. And what we see here is that unlike Lip Essentials, M-Copper had the foresight to register their brand as a trademark, and they made it a legally protected asset. And without that legal foundation, they would not have been able to enforce their rights, which is the challenge that Lip Essentials is having now, and most upcoming businesses and SMEs are having, where they really cannot enforce on their brand and on their value because they do not have a legally protected asset on it. I am joined in this panel with two ladies I respect who are in different fields. We're going to be looking at different sides of the divide. So we'll have the marketing side of it and also the IP side of it. And just building onto that, I think, Rima, you can share with us, you work with a lot of entrepreneurs and a lot of companies on brand identity. What to you makes a brand truly compelling, and how can one start building that brand?
Wonderful. Kind of looking forward to this conversation. Definitely the like the low side is always a jargon for me per se, but I can give you a marketing and brand perspective of what a brand is. And as you're growing your brand, this will really help in that conversation as well. So I don't know whether, and Jerry, you can take us to yes, just one more. So this particular slide over here, can anybody tell me if you can identify any of these brands? And you can either put them on the chat or you can unmute yourself and tell me what are some of the brands that you can recognize in here. Diana says Shell. Okay, awesome. Carrefour, Shell and Kenya Airways. Okay. Ooh, lots of people knowing Shell and Kenya Airways. Fantastic. Kenya Power. Yes, NCBA. Kenya Power, you can't miss it. Soul Generation, well done, Michelle. Dove, yes. Super Sport, Emmanuel, well done you. And then we've got Cynthia and Diana also saying Dove. Fantastic. So imagine they are literally no words that are in front of you. It's just that icon. It's just literally the icon, right? So my second question to you would be, the brand that you have selected or you have actually recognized, what is the emotion it evokes in you? What do you think that particular brand, in your opinion or your perception, that it stands for? What does it stand for? So for example, Emmanuel, what does Supersport stand for? Cynthia, what does Dove stand for? Or Soul Generation? Wamboi, what does NCBA mean to you when you see that? What emotion does it evoke in you? Mary, you mentioned Kenya Airways. What emotion does Kenya Airways evoke in you? And so on. I just want to know, again, either unmute yourself or you can put that on the chat. And tell me. Wamboi says premium banking. So NCBA immediately has the premium banking that comes to your mind. So it means that that's the emotion that evokes. KQ safety, that's pretty amazing. If you ask my husband, when you say KQ, he says Delays, exactly. Chabet got it absolutely, so every time he thinks KQ, he always says delays, always delays. Jerry Supersport, Sunday football with the family, that's pretty cool. Supersport, the live sport, ESPL, okay. EPL, lively, intensive commentary. So there's like anything sports you want to go to, you can rely on Supersport for that. They'll go to even the local ones now and so on and so forth. So there's different things that a brand evokes. And my pointing here would be that are you as a company or the person working in this particular organization helping to evoke a particular kind of an emotion, right? I promise you, Chabet, as well as Mary, KQ generally feels like they want to evoke the emotion of safety for everybody. However, because of the customer experience, everyone thinks now the brand of KQ as delays. All right, so you can live your life in values of what you want to be perceived as. However, the customer experience or the experience that you give to your customers or what they experience is actually what they perceive. And so KQ is a very good example of that. Safety is what they would want to have everybody experience, but delays is actually what they experience. So basically means that KQ needs to up their game to make sure that now they're aligned to their values, they're aligned to their story, they're aligned to their culture, right? So a brand, even if there's no name to it, the same way that we've actually been able to identify all the brands in here, has a certain story it tells. It's a certain value that it tells, right? And so, Jerry, just go to the next slide. And so I just wanted to yeah. So I know for IP purposes and what Divina has said, Loretta has said, and Chibet is probably going to be saying just now as well, is the description or what I'm actually mentioning about the values may not be trademarked, but that is what stays with our customers. Not functionality of our brand, but also the emotion of our brand. We buy things because we're emotional. We're emotional human beings. We're beings. And so the logo, color, typography, templates, etc., those are the elements of a brand that now I suppose you can actually attach an IP to. But your brand culture, promise, and your story that you're telling, your values that you're actually evoking in people, and the kind of like campaigns, Divina mentioned campaigns, things that we're actually educating people or sensitizing people on. And if that is not what you're living as a brand, then your brand reputation goes down the drain, pretty much, right? And so I want us to also think around as we're looking at IP that yes, you have your logo and everything that is trademark and registered, and you're good to go with some patents, and I'm sure we're going to be talking about that as well. However, if you're not living your promise, that everything that you have done to register it, whether it's international or local, is going down the drain because your brand reputation is about the perception of your customer. The same way that we have actually just perceived something as a brand of KQ as an example in here, right? So I just wanted to leave you with that example of what a brand is in a more simplest format. And so Loretta, on back to you.
Thank you for that, Rima. I like that you have separated brand elements and your brand, because I think most people get confused between the two. They attach the brand elements as the actual brand rather than what the brand does for you. And I like that you have shared that a brand is more than just the logo, the color, the typography, and all of that. It's actually the story or the consistency and the emotional resonance that one builds with their clients. And the brand elements being what is being protected, what it protects is not just the elements, but rather the value that you are promoting and the goodwill that you're promoting with your business. To Chebet, what happens? We've talked about Mkopa who have come up who actually registered their trademark, and they were able to enforce that trademark and defend it legally. As Rima has shared, she really does not understand the legal jargon, and I'm sure it is the case with most people. They really don't understand when we're talking about intellectual property or IP, what exactly are we talking about? So can you please share with us what exactly is intellectual property, and why should even the smallest Kenyan business care about it from day one?
Thank you so much, and I'm happy to be here and share a bit about IP with everyone, and I'll try and make it as simplified and practical as possible. So if we can move to the next slide. Great. So this is as simple as I can make an explanation of what intellectual property is. The keynote speaker already gave us quite a bit of background of what intellectual property is. Its definition is just creations of the mind. So if you think about someone owning a farm full of cabbages, think of intellectual property as property in the same way as you'd have property of a car or something tangible, but this is something that you've created in your mind, and so it's not tangible, but it is still property. So there are different kinds of intellectual property rights, and I'd like us to have that as the initial understanding to the conversations that we're going to have, so that at least by the end of today, we're not going to be saying I'm going to patent my book. Rather, we're going to say I will copyright my book. So there are different types of intellectual property rights. And one of them is copyright. So copyright will protect the creative works. So if you think about books, music, film, in Kenya, we protect software under copyright, and also data compilation. So if you have a data set, that can also be protected as a copyright. And copyright protection is automatic. So this means that you do not have to register it. However, it is very important to register it to prove ownership. So once you go to court, if you don't have that certificate showing that you are the owner, it will be much more difficult for you to prove that you're the first owner of this, say, book or whatever it is. And also, if you want to commercialize your work, so if you want to license it, you want to sell it, you need to have that certificate. Then under the other arm, we have industrial property. So under industrial property, we have patents, utility models, trademarks, and industrial designs. So patents protect inventions, and this is for a new product or a unique process that can be applied in an industry. For a patent, it has to meet 3 requirements. So one, it has to be new. It's not something that has been invented before. Then it has to be non-obvious, which means that it is the invention is not very straightforward. So people within that field should not be able to easily identify this as something that has already been made or something that's not so obvious. Then useful means that it has to be applied in a practical and industrial way. Then we have utility models, which some people call petty patents or smaller patents. And there are smaller innovations. So here you'll tweak an existing product and which makes it either work better or easier. And for here, you'll get a shorter protection. So for a patent, you'll get 20 years protection. For a utility model, you'll get 10 years protection. And it also doesn't go through the strict examination process of a patent. Then we have trademarks, which for our conversation today is what many people go to when they're thinking about IP. And this protects the symbols, the logo, the name, the sign, and it helps to identify or distinguish products or services. So the goal of a trademark is to communicate to the public the source or the quality of a product or a service. It's also so that your customers are not taken away by other people within the market. That's the goal of the trademark. So it guarantees the origin and quality of a product or a service. Then we have an industrial design. So here, think about a Coca-Cola bottle. This is the protection for the look and feel of a good. So it's the shape, the pattern, the design, and you'll get 5 years. Then we have the geographical indications, which is a sign used on products that have a specific geographical origin and possess qualities or a reputation that are due to that origin. So here, think about champagne wine. You can only use the word champagne for a wine that has been, or that originates from the Champagne region in France. Or if you say Swiss-made watches, these are watches that are made in Switzerland. And the goal of this is because it identifies that a product or a product is originating from a given place. And normally that is because of either the quality of the area. So if you talk about tea, in Kenya, we don't yet have a law protecting geographical indications. It somehow falls under the Trademark Acts, but not very well. So the goal is, if we're talking about tea, let's say Kericho tea, the quality of Kericho tea is high because of the geographical landscape. The soil, the climate makes the tea have a higher quality. So if you say Kericho tea, someone will know that I'm getting this tea, I'm getting this quality because it's from that area that has high quality. Another IP that we can talk about is trade secrets and confidential information. So for this, there's no act. What protects it is copyright law. So it protects the valuable business knowledge that you might have that gives you a competitive edge. So think about the Coca-Cola recipe, the KFC recipe, they've been kept as trade secrets. And here, how you protect them is to strictly safeguard them, which means using non-disclosure agreements, restricting access, training employees to keep the information secure. There's I don't know if it's to call it a rumor that for the Coca-Cola recipe, there are only 2 people who know what it is. They can't fly on a plane at the same time. Just generally looking at ways in which that can be completely secured. Then another intellectual property right or cousin or sister of IP is the traditional knowledge and traditional cultural expressions, which has been talked about in the very beginning. So this protects traditional knowledge and the cultural expressions within a community. In Kenya, we have an act protecting this or providing for, governing, let's say, the use, access to traditional knowledge and traditional cultural expressions. I guess because of the nature of it being very communal, to my knowledge, it has not really been implemented as such. So the Copyright Office, the Kenya Copyright Board, KECOBO, has a mandate to collect or rather to keep a repository of these traditional cultural expressions. To my knowledge, that has not yet happened. But recently, last year, we had an international treaty being adopted, which is the World Intellectual Property Organization Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge. And once this comes to play, once 15 contracting parties ratify it, it's going to introduce a new disclosure obligation. So where a patent application has been, where there's a patent application, where the invention is based on genetic resources or traditional knowledge, the applicant has to disclose this. So this might play into what our keynote speaker talked about, where there was a Maasai biodata being collected. In such a scenario, once you go and say you want to come up with a patent for this, you have to disclose that there was either genetic resources that was involved or traditional knowledge. To my understanding, this is so that there's benefit towards the community. But to your question about why all these intellectual property rights are important, why it is important to register, say, your trademark for your brand and all the underlying copyright. I'll say, so for intellectual property, there are 2 reasons why we have it. One is to reward the person who has either created or innovated so that they are able to either recoup their costs, but also to incentivize them to continue creating. If you have a brand and you have a service, you have a good or a service that is behind your brand, you're going to use a lot of money to come up with these services, these goods. If you don't protect it, you will end up losing out on that. But at the same time, the protection is so that you can be rewarded for your hard work, your financial, the finances that have gone into it. And also at the same time, more money, more incentive to create. And so you're able to either boost your business, the services that you provide. Another thing is looking at IP as a revenue generator. So once you protect your IP, let's say you have a trademark, you can either decide to use your trademark to boost your brand. So it means to get more awareness about your brand. But you can also decide at some point that this brand has grown so big, and so someone wants to come in and buy it. There's a case of Nice and Lovely where the owner behind it started off in a shop in a room behind in River Road. And then he grew his business so much that I think it's L'Oreal ended up buying his business, his beauty business, for a lot more money. So for him, you have to have an IP strategy. You can decide that the IP portfolio that I have behind my goods and services in the brand, I am building it to the point where I'm going to end up selling it and getting more money from it. Or you can just decide that you're going to use it to defend yourself against anyone who might be coming in with M-Corpo or trying to end up taking away clients from you based off using your IP or not having IP registered. I'll stop there. Thank you.
Thank you so much, Chebet, for that. I like the fact that you have mentioned that one of the reasons why we have intellectual property is so that you can reward the hard work that goes into coming up with ideas. I think I'd like to pedal back to the lip essentials, the battle of the lip glosses debate, where a lot of money was actually poured into this particular business idea, the product, and all of that by this small business. They had spent a lot of money only for them eventually to lose a lot of the traction that they had gotten because they did not have any proper protections in place. And many small businesses overlook this part of taking care of these nitty-gritties of compliance, of getting these protections, because they're like, I'm waiting to get more money, I'm waiting to, build a bit more value in my business. And seeing the idea of getting value or goodwill being far off and not something that we can look at in the near future, only to realize that you never really can tell with the market how fast or how slow your product is going to grow. And it's only better out of abundance of caution to just have those protections in place, not only just to have the revenue in the end, but also to reward you for the amount of work that goes into coming up with these businesses, these concepts, these products and service lines. So I'd like to throw it back to Chebet to kind of like ask the questions. Now, with so many business, like what I've shared right now, it's so easy to come up with a business. I just go onto ChatGPT, I type the idea that I have, it gives me a business plan. Then I go to Canva, I create some posters and logos and whatever. I open an Instagram account, a TikTok account, and I've launched a business. I don't even have to go to the company's registry or BRS to register a company. I'm already trading. So what are the common mistakes that you are seeing within the digital IP space that businesses and entrepreneurs can actually consider as they're starting out their businesses or running their businesses?
Okay. The first one I think of is not doing an IP search. It's very simple. It's going the same way you went to online to start up your business or whatever, think about it. Is the same energy and urgency in which you need to go and search the business that you're thinking about. Go and find out who is doing it. What names am I thinking about that are likely to be already trademarked by somebody else? More often than not, our ideas are not very unique. So it means that somebody else has already thought about it. So what this will help is, one, it will help you make sure that no one will come after you've spent time and energy, and then you've done something similar to somebody else. Secondly, it might also help you to just think differently. So this is being done, but this is not being done. So this is the gap that I can fill, which will help you in the end, because then your business or your service that you're seeking to provide will actually have a niche market, as opposed to just being a Coca-Cola shop next to a Coca-Cola shop selling the same thing. Then another thing is not having a clear ownership of agreement. So often we'll have a business where you're not the sole business owner, you have a partner, or you are coming up with a software, and so you need a software developer to come in and develop the software behind your business. So if you do not have a proper agreement at the onset where you're saying that this IP is going to be owned by either the company or this IP is going to be owned by me, then you're going to risk having challenges later on, which is going to end up causing you to spend more time. So having an agreement at the very beginning when you're ideating is an important thing. Then another thing is poor documentation practices. So where you have a lack of proper records on the creation, the use, the transfer of IP, this is likely to weaken or create an issue later on. And then also another thing is where we're using third-party technology without the rights that are there. So if you are using, of course, when we're talking about digital, you're going to ChatGPT, you've not read what the user, the rights for the terms of reference or terms of service for ChatGPT are. You don't know if you're using different softwares, whatever, if you've not understood what the actual rights that are available to you, or what you're actually giving this third parties, right? What rights you're giving them, you risk either coming up with a situation where you're losing on the IP, or you're not even able to own the IP behind it because you've not cleared the rights. So those are just the ones which I'd think of when you're starting to think about your business. These other ones on the list that you're seeing, the 10, these are just the general ones, the IP mistakes to avoid generally. So it also includes, if you're talking about a patent, if you disclose before application, that could harm your registration. If you don't consider an IP strategy from the very beginning and map that out, that can also be a problem. And also, when you're coming up with a budget of your company, it's very important to think about IP as a budget line, because many times people will think of it as a nice to have and not something that is actually very important or that is beneficial to you. Another thing to note is that the different intellectual property rights are protected territorially. That means that if you register for your trademark in Kenya, you'll get protection in Kenya. If you're going to open up your business in Uganda, Tanzania, China, you have to consider to register in those countries so that you can get protection in those countries. But also, it means that you have to figure out which countries you're actually going to go to. Because if you register in Ethiopia and you don't plan to go and open your business there, you're losing out. And this is what I mean when I'm talking about having an IP strategy. So you have to figure out what IP works for me, which one will benefit me more, and not to think about, oh, I want to have a patent, because patents are the big IP rights when you're not even having any inventions in your company. So those are some of the things. So if you think about the wrong country in which you want to protect, or you are going to open in another country and you don't consider that, or a market which you think that they are likely to counterfeit your products, let's say. Those are things that you need to consider. I think I'll stop there. Then I'll answer the next one.
Thanks for that, Chebet. I think something that we often overlook, I think also Diana has intimated it in the comments, is when we're using all of these tools that makes our work easier, we tend to not look at the terms of reference or the user guides, and we are just using it. I think there was a debate that had arisen, I think a few weeks ago, about people who use, I think it's called CapCut, to create their images on videos for TikTok. And they updated their user reference to say that anyone who is creating their videos on the platform or on the application, that the owners of the application could use that content to actually promote their business. And most people, you just go there, you create your things, and then all of a sudden you're seeing your video being used somewhere in the Maldives to promote somebody else's business. And you find that you actually consented to it because you used the application and you consented to the change of the terms of reference. So it's something that I think most people tend to overlook, but it's quite important to look at, like the copying, overlooking trademarks or unlicensed, using images that are already licensed, music that is already licensed, and you probably don't know about it. There's a lot of risk around it. So I'd like to throw it to Rima. When you're helping businesses to create brands that help them stand out, what are some of the things that you're doing while helping them to create these brands to help them ensure that they're not unknowingly copying or exposing themselves legally? Because with everyone is trying to create a brand for themselves, but how can they do it well and not to expose themselves legally?
Okay, great. I don't do it from a legal perspective per se, but I will tell you that one of the things in marketing that we do is what we call the USP, unique selling point. Each business, whether you see, for example, even if you take the big telcos, right? So you've got Safaricom and Airtel right in front of you. Each of them have something unique about them, right? And if you have that uniqueness, that helps you stand out from your competition. So whenever we do strategy, when we do marketing strategies, we always tell you, let's do a competitor analysis. Let's understand what are your strengths versus what are your competitors' strengths, what are their weaknesses, and what are customers looking for with regards to improving that customer experience, improving the functionality, improving the solution that you're providing to them, whether it's a product or a service that you're providing. So from coming from a perspective of the customer and what the customer actually needs in their lives, you know, like to make life easier. So anything that we purchase pretty much right now is to keep convenience, right? We're buying clothes that we can look good, but we also want to make sure that we actually covered and oh, there's somebody, there's a Donna with a trademark. That's really interesting. Who's just entering into this. I would really like to ask that question on if they've really trademarked their name or not. So ideally, what we do basically in the brand and in the marketing is help you find that uniqueness. Again, people buy from people that they like and they trust, and they actually connect with your values, which is why our marketing now is it's not just about like telling you what the product and what the service is, but really bringing out what is the value of that product and the service, right? And we're finding more and more that even as we're getting our brands closer to their customers. So for example, we've got a manufacturer who's doing water tanks, right? And what they know is where customers are finding them is on Google searches. So obviously they want to be on the Google searches for terms like water tanks in Kenya. And then, so for example, are they on the first pages of searches? Because nobody actually goes onto the second or third pages. So we provide keyword SEO for their websites to be on the first pages of searches, and we do all the activities in and around trying to get them on the first pages of searches. And if anybody's in marketing in here, you know how difficult this is in this day and age, especially on Google. Second thing, of course, now is coming as AI and whatever. Now, what has happened, and this is an actual real problem that's happening facing this particular customer, is that there is somebody or an organization or whoever it is who has copied the exact website and called it in a different name. And what's happening here, and this would be really interesting for especially the lawyers in here, Chibet, Loretta, and Divina, is that the copy person, the counterfeit or the fake one, is actually like if they just change the name to the name of the company with a tank or water tank, and then they're trading as if they're that company. And then what's happening is that people are purchasing directly from them because the website exactly looks the same. They're using the name, you're using the products and everything. And then, of course, there's no delivery. And so what happens is then you've spent, like, for example, for a 10,000 liter water tank, you spent thousands of shillings to send to like an M-Pesa, and they have a proper till number and everything. And then it's gone. It's completely gone. And you shut that down, and there's another one that's come up. You shut that down, and there's another one that's come up. And most of that money, what they're doing is really clever again, is that they're using it to actually run Google ads, so search ads on Google, so that again, when they're searching for those particular tank companies or those particular keywords, they're right up on that space so that you can click on it and then come for it. So counterfeiting is actually a big problem that we're actually seeing even in marketing currently. And so obviously the business as a business then has to make sure that, again, we have to run campaigns saying that is not us. Please check, this is our correct number. And I remember even Safaricom some time ago was doing that. We do not call you from any different number. This is the number we will call you from. And so making sure that those kinds of campaigns running with information, and education is a really important part of ensuring that people can now identify the right brand for that as well. And one of the reasons why I was asking Divina about this is if that TM is on that, though I don't think it's going to work, because I think the fake company is probably going to just copy the entire thing again with the TM as well, right? But yeah, so I mean, these are some of the things that we're actually going through right now. But big part of it is ensuring that even as a brand, so like for example, just distinguishing between the correct company and the fake company in here, making sure for the correct company is actually making sure that the delivery and the customer service and the customer experience in the entire customer journey of this person who's purchasing a tank is going to go through until they're satisfied. The satisfaction itself is already going to like up their notch in terms of what do I think about this particular brand. However, the fake ones are making a dent on this company right now, you know, obviously because people don't know. They're thinking, oh, but then look at this, everything is the same company name, sort of a thing. So it's like a really big issue that's happening. But consistency, turning up, and especially for smaller brands that we're working with right now, we tell them, it doesn't matter that you've started right now. Where do we want to go to? Let's achieve objectives and targets on a month-on-month, year-on-year basis. Let's show up consistently as who you say you are. If you promise that you're going to deliver anything, say for example, biscuits, you're delivering biscuits in 10 minutes, make sure you deliver the biscuits in 10 minutes. If you're saying that there is a consistency in the quality of the work that you're doing, make sure you show up with that particular quality. If there is a gap in the market, then look in that gap and see how you can be able to highlight that and say that, listen guys, there's so many different other players in the market. So there's some really saturated ones, of course. But then what we say is you make sure that you can get really unique about it. And another thing is get certifications. So again, for us, we're big on certifications. So if you have a trademark certification, you have eco-friendly certification, you have something in and around like your KEB certifications, your quality certifications, whether it's local or international, that really does help us to tell the story of this particular brand. Just to put it into a nutshell. Yeah.
Thank you for that, Rima. Something that I've picked from what you have said is that, you know, authenticity is great, but consistency does matter. And for every business, there has to be some level of vigilance. I think we usually think because I've opened the business, it's out there, it's going to start generating money on its own. I don't need to kind of like check on these nitty-gritty things. I like what you talked about. I think Divina alluded to it. We call it in law domain squatting. So there are people who actually make a business out of domain squatting, where like a particular business has opened. So their domain name is .com. So you'll find some people who will open other domain names and then they will change something very small within the wording. So instead of, when we talked about Mkopa and Mkopo, they just changed the last letter. Instead of it being A, it's O. And usually when you're doom scrolling on your phone and you're thinking, okay, fine, you talked about water tanks and you're thinking, I need to buy a water tank. I don't think you really look at the spelling of the domain that you've gone to. Probably you had, this business actually delivers very nice water tanks. And then you find now the domain of the person who is domain squatting on another domain that is the same name or .org or .what. As a consumer, I don't usually go through the loops of verifying if this seller is actually who they say they are. I just buy because, you know. And I think usually the burden is on the business to ensure that they are vigilantly protecting their brand, so that it is not said that I bought water tanks, because they won't come and say that I bought water tanks from .org. They'll say I bought water tanks from Loretta, and Loretta took my money and they did not deliver. Like you said, like these fraudsters go the extra mile of even registering the pay bill to the extent that it closely resembles your business. So it requires a lot of vigilance on the part of the businesses to ensure that you're not only protecting you're not only doing what needs to be done by having your products and service lines in check, but you're also protecting like the brand in itself. We've talked about the digital marketplace that we're currently dealing with now, and Rima has spoken about how working with small businesses and ensuring that they have all of their branding above board. We have seen a rise in user-generated content, where businesses are engaging third parties who have a bit more following online to help them kind of push their businesses and push their products. I'd like to ask Chebet to share with us, like in the case of a user-generated content arrangement, because I think you talked about contracts when you were sharing about the definition of IP. Who owns what in a scenario where I have co-opted an influencer to help me push my business? Do I own whatever they have created, or do they own what they have created? Because in actual fact, it is their creation. It's their idea. They made the idea a reality. They're using it to help my business. So who owns what, and how can businesses align their contracts or their stream of business to actually co-opt these UGCs and other people who are helping them to build their brands?
Okay, thanks for that question. So when you're talking about copyright as the IP right that I'll focus on, the owner is first the author. So whoever is the author of the photograph or written the script or whatever, that will be the owner. However, this depends. So if you are an employee, then the copyright will be owned by the employer. If I have commissioned someone to say draw for me some piece of art, I would own that by virtue of having that work as commissioned work. What I'd say is most of the time these collaborations are happening, and number one, have a contract, because the contract should clearly state who owns the IP. So even in a commissioned work, go the extra mile and say that I've commissioned so and so to do this work, and the copyright is assigned to the company or me who's commissioning the work. So it normally depends in if you're having a collaboration. If someone else is working with you, or you've asked someone to work with you, it always depends on what the contract is, because you can also have a contract where it says that we're working together, party A owns the contract for 5 years, and then the copyright for 5 years, and then it will revert back to somebody else. So it also depends a lot on what the contract says. But what I'd say is, number one, in copyright, the author owns the copyright unless it has been assigned or licensed to somebody else. If you're an employee, more often than not, okay, the law says that the employer owns the work. However, that can also be a bit itemized in a contract. You could say that for specific things that you're doing together, you might have co-ownership. If it's in a university, for example, as a staff member, the university owns the copyright. As a student, there could be an understanding in the IP policy on who owns what, who has a share in what. And this also turns into, if you're in a university and you have a patent behind, you have a project, let's say, and the lecturer is guiding you on how to come up with this project. You leave the university and now you want to have this product. This project could become a product, and you have a company for this product, and you have a whole brand behind it. And this has happened even in our university, where we have had students who started with their product from when they were during their studies, come out, and now they have fully fledged companies based on that. But if the IP policy said that the university owns 40% of it, that is something that you have to consider when you're starting a business later on, because then you know that I don't have full ownership in this. And so either I need to pay out and get full ownership, or have an agreement. So those are the things that you need to consider. Yeah, I hope I've answered the question.
Yes, you have. I just have.
Sorry, I'm just
I
going to quickly just mention something with regards to that and what she said is we do this quite a bit, especially because of the fact that we do marketing digitally and physically. And we do have, like, for example, people creating content, so the content creators, whether it's influencers or not. And it's really crucial. The thing about doing the contract, even if it's a simple contract that just says who actually owns the content after it's done and after it's put up, is really, really crucial. And we actually make sure that that's actually done right from the start, even before the content is created. So just wanted to add that as part of a best practice that we actually use in marketing.
Thank you for that, Rima. I was actually going to throw it to you, but I guess you jumped the gun and you've answered the question that I was going to ask, because I was going to ask from a branding perspective, things that you do advise your clients when it comes to UGCs. Because I think it's something that people overlook in terms of they don't really put any value on that work that has been created, and they think that just because I have asked you to create this product for me or to create this video for me, then I own whatever that you have created. But there are a lot of nitty-gritties that go into that particular arrangement where businesses have to be very vigilant to ensure that it is clear on who owns what. Because as we discussed as we started, that some of these things, the UGCs, the businesses, everything that we are doing actually aligns with the fact that it is a revenue generator. We are in this to make money. There is nobody who is here just to have fun and kikiki and go home. Everyone is looking to make some money. And to make that money, you have to be very clear where your money is coming from. And usually it boils down to the contract that you create. We are running out of time. So what I want to do is I want to take it to a rapid fire to both of our panelists to kind of like share with us one mistake that you have seen over and over again in your respective fields. For Rima, within the branding or marketing field. For Chebet, something that you have seen within the IP space with regards to businesses. And then how can we avoid it? If you have any questions, please feel free to put it in the chat box. We'll be able to answer them. So I think Rima and Chebet, you can agree who goes first. But yeah, what's a mistake you see over and over again, and how can people avoid it?
I have to go first because I think I've already answered the question. And so I'll just do a summary of it. The last slide that I had about the IP pitfalls, that's more or less just a general thing. And the goal behind, rather the overarching thing is not considering IP at the forefront, at the beginning, and thinking about it at the very tail end of when someone comes and sues you. That's it.
Okay, got it. And then for me, it is, and I know that this is not, hasn't been really like picked out and stuff, but a lot of these AI generated or Canva generated logos that you're creating, and you're saying it's just a logo, let me just start up the business and just put it there. The same exact icon that you're utilizing is then completely used by a different company in a different space. And you'll, like, for example, I am sure you'll come across it. I know I have for a fact actually seen something like this as well. And a lot of companies are like, oh, you know what? I just AI generated it and I paid for it and I did whatever. But even those AI generated things, I would recommend highly to then think about your target audience even before you start doing brands. What is it that they like? What is it that they dislike? Don't do colors that you love. What is it that the person on the other side? So for example, a lot of banks do blue color because blue actually stands for trust, right? Red stands for excitement, for example. So if you're doing things around what your customer would then get attracted to you, then that's the right direction to go. Even if it's AI generated, make sure that it's actually unique. Like even humanize it and make changes to it even before you start utilizing it as an identity for your brand. And remember, the brand is not the logo and the colors. The brand is what you're giving as a customer experience and standing for as values in front of your customers. Yeah.
Thank you for that, Rima and Chabet. I think one thing that I have picked from both of you, it closely resembles when we're doing the icebreaker, we were asked what advice have we been given recently, or the greatest advice we've ever been given. For me, it is when cutting down a tree, 80% of cutting down that tree is strategizing how you're going to cut down that tree, and 20% is actually cutting it down. And I think it's the same even with business. A lot of work goes into coming up with these businesses, the concepts. You just don't open a business and start and you say, I'll figure it out as I go along, because you actually get into a lot of problems, costly problems, when you work that way. So there's a lot of vigilance, a lot of work that goes into establishing a business, establishing a brand. And it's not just about taking what is trendy right now. It's about actually thinking about what Rima has said. Think about your target audience. Who are you actually looking to come into your business to partake in the service that you're providing? What Chebet has mentioned, that you have to actually do an IP search, actually establish what is there, are people using the logo, so that you're not building on something where you're just going to be wasting your time trying to defend the value that you have just created, or the goodwill that you have created with the product that you've started. So I don't know if there are any questions on the chat box. Probably Diana can assist us. But mine is just to say thank you, guys, for attending this panel session. We have a few minutes before we can log off. Diana, are there any questions that our panel members can consider?
No questions in the chat box.
Okay. In school, we were usually told the teacher would say, no questions means you have all understood. I know it is information overload. There's a lot to appreciate. There's a lot to understand. Even what we have discussed, you can't properly contextualize this topic in just the 2 hours that we have been here. I think we will share this recording. You have access to all of our email addresses. Please feel free to ask any questions that you might think of as we go along. I think I can hand it over back to Jerry. Thank you.
All right, thank you very much for that session. We're gonna head straight into feedback. Kindly do let us know what you thought about this session. You can scan the QR code or use the bit.ly link. Diana will paste it also on the chat box. Quickly scan the QR code and leave us feedback. Be as candid as you can. Your feedback always helps us to better these sessions and improve the ones that come after them. Also, at the end of the feedback form, you'll be prompted to leave a Google review. So kindly do that for us as well. It does help with building trust and reputation for our businesses. Thank you so much. Also attached to also on the chat box, you'll find the simplified copyright handbook that you could peruse through and ask Chebet any questions on LinkedIn as well, or on email. Feel free to do that as well. We have come to the end of the session. Thank you very much for attending and for participating and for just being here and listening to our panel and our keynote speakers, for engaging with us. You can also continue engaging with us on our social media platforms. Diana has pasted for both Panike and SMC Legal, as well as AD Marketing. Feel free to reach us there if you have any questions. We'll make sure to answer your questions as they come through to us. I think that's a wrap from us. Once again, thank you very much. Diana, do you have anything else to add?
No, none. If you truly did enjoy the session, please, we would love to hear your feedback. Other than that, keep an eye out for more sessions.
Yeah, yes. The link to the recording will be sent to your emails as you had registered on the registration form. That reminds me, if you have not filled in the registration form, kindly do so that we could send out the recording via your email. All right, thank you very much. Thank you to our panelists and our keynote speaker, and thank you for all of you who attended. See you in the next one. You may leave at your own pleasure.
Thank you. Bye.
Bye.
Thank you.